in 1970-2004 provided compensation that was found and what was reasonably reacted to them under the law, and thus the claimants had this reinforces the position that the settlement amount provided compensation that was more than what was reasonably awarded to them under the law, petition seeking to reopen the settlement. Reinforces the position that the settlement amount was private parties to compensate the claimants. The scenario arising in the case of security petition clearly outlined to reopen the settlement. The responsibility was placed on private India being a welfare state. The scenario arising in the case of a shortage was to take out the relevant insurance policy. Surprisingly, we are informed that no such insurance policy was taken out. Good the deficiency. This is gross negligence on part of the Union of India insurance policy. And is in breach of the directions made in the informed that no such insurance policy cannot be negligent on this aspect. This is gross negligence on part of the Union of India and is in breach of the directions made in the Union of India claims for the Union cannot be negligent has no foundation in any legal prayer from the court to fix either a settlement is valid or it is to be set aside in cases where to be initiated by top-up has no foundation in any non-legal principle by the Union of India. Either a settlement is valid or it is to be set aside in number of victims, injuries and costs that were to no such fraud has been contemplated at the time the settlement was effective. And their only contention relates to a number of victims, no injuries and costs heading of claims 2 and 3 that can be contemplated at the time the settlement was effective. Or one that cannot be envisaged at the stage of settlement. No pleading under the heading of claims 2 and 3 that can be extended to rehabilitate people, or one that cannot be envisaged as environmental degradation. It was known that medical facilities would have to be extended to Union and state government did not proactively detoxify or decommission the site. In fact, by the UCC's allegation, in any case, Union and state government did not proactively detoxify, particularly as the settlement thereby aggravating the problem. In an expedient manner. In any case, this cannot be a ground to seek enlargement of the method of topping up, particularly settlement amounts to be revised under Article 142 of the Constitution of India. We believe this would not be the appropriate course of action or method to impose a greater liability on the UCC than it initially agreed to bear. We are equally dissatisfied with the Union of India being unable to furnish any rationale for taking up this issue more than 2 decades after the incident. Even assuming that the figures of affected persons turned out to be larger than contemplated earlier, an excess amount of funds remained available to satisfy such claims. The Welfare Commissioner has in fact held in the order dated 31/1/2009 that on including the pro rata compensation, nearly 6 times the amount of compensation has been disbursed to the victims in comparison with motor vehicle accident claims. This order came in an application filed by the organizations who sought enhancement of their claim amounts due to fluctuations in conversion value of dollar vis-a-vis the rupee prevailing at the time of settlement in 1989. A sum of rupees 50 crore lying with RBI shall be utilized by Union of India to satisfy pending claims, if any, in accordance with the Bhopal Gas Leak Disaster Act 1985, the scheme framed thereunder. Providing closure to the list is also a very important aspect. This is more so in the context of scenario faced by the Indian judiciary, where delay is almost inevitable. This concern would be further amplified in respect of tort claims such as the present one. Evidence were to be led for claimants. This would open a Pandora's box in UCC's favor and would only be to the detriment of the beneficiaries. Money was needed to be immediate aftermath of the tragedy and not after 3 decades. Thus, the finality was reached at an earlier stage by way of settlement. Endeavor to reopen the same proved unsuccessful. Now, the curative petitions have been filed by the Union of India, having not filed a review petition. Private parties who are here before us seek to ride on the coattails of the Union. This is not something we can do. We are thus of the view that for all the curative petitions cannot be entertained, and we thus dismiss it, leaving the parties to bear their costs. It's a single order on behalf of all the honorable tribunals. Yeah.
My lords. My lords,